Welcome to this week's discussion about the judiciary. We will be talking about the formal rules of the judiciary, including where cases come from and how they progress through the system. Next week, we'll be talking a bit more about judicial behavior. So, the Constitution is actually pretty vague about the components of our judicial branch. If you read the Constitution, the mentions of our judicial branch are in Article 3, and they say the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. The rest of the article goes on to give a very rough outline of primarily what the Supreme Court will do, not the lower federal courts. So one of Congress's first actions was the Judiciary Act of 1789 to set up the system of jurisdiction of the federal courts and just the court system as a whole. So some things to remember that come out of the Judiciary Act of 1789. First, federal courts have limited jurisdiction. That means they can only hear certain cases. They cannot hear every case. So when people say, hey, don't make a federal case out of it, the reason is that most things are not a federal case. Federal courts have a three-tier system. So there are district courts, the most common trial court, circuit courts, which are the most common intermediate appeals courts, and then the Supreme Court, which has mostly appellate jurisdiction, but some original jurisdiction where they actually hear cases for the first time. We'll talk about all of that in a minute. And finally, Congress defines the Supreme Court's appellate jurisdiction. The Constitution spells out the original jurisdiction of the Supreme Court, but everything else that the Supreme Court does is actually controlled by Congress. Not on a day-to-day basis, but Congress has empowered the Supreme Court to act or refrain from acting in certain situations. So, generally speaking, appellate jurisdiction means the ability to hear appeals from, in this case, the circuit courts below. And that has been reframed from time to time, most notably after the Civil War in particular. So the court's ability to do things has been changed. Not frequently, but it has happened. One thing to note on these slides is where you see SCOTUS or SCOTUS. That means Supreme Court of the United States. It's a common acronym, but it may pop up. So to look at the types of cases you might hear in federal court, you can kind of separate these out in a variety of ways. One way in which you can do that is between civil, criminal, and then kind of what I've labeled other. So civil lawsuits are lawsuits between individuals or organizations based on things like contracts or civil laws that people believe have been violated or constitutions. The key thing is that this is not a criminal matter, that someone's being charged with a crime and could end up having to pay a fine or go to jail. It's a civil case where you may end up having to pay money, but between a relationship with two or more parties. Criminal laws are when the government charges someone with a crime. And then I have this kind of other category because there are other cases that don't fall neatly into those categories. Things like bankruptcy, trade infringement, patent and trademark infringement, military tribunals, etc. Those have their own special courts. So if you're looking at this hierarchy here, what you see at the bottom is all of the entry-level courts. On the one side, you see the district courts. That's primarily where most of the cases start. And in fact, it's where we're going to be focusing on today, the district courts, the appeals courts, and then the Supreme Court. But at the same level, you have tax courts, claim courts, trade courts, and then the military courts start at the Armed Services Courts of Military Review. So there are different pathways up through the system, and those sometimes represent different types of cases. Michigan has two federal districts, the Western and the Eastern. Flint is in the Eastern District, which is housed in Detroit but has offices in Flint, Ann Arbor, Port Huron, and Bay City. Each state has at least one district, but many have two districts or more. Then on the circuit court level, When we move up a step from the district court, so for appeals matters, if you look back at this chart here, when you move up, there's an appeals court at some level. So it either goes to the military appeals court, the federal circuit court, or 12 geographic circuits. These are those 12 geographic circuits. It also labels the federal circuit on here. But there's the DC circuit, then 11 numbered circuits. Michigan is in the 6th circuit, along with Ohio, Tennessee, and Kentucky. So another way to divide up cases that enter our federal judicial system is based on whether they belong there at all or whether they belong in the state system. So civil cases on a federal level have to meet one of two criteria. Otherwise, they belong in the states. They're state cases. Civil cases either have to have subject matter jurisdiction or diversity jurisdiction. Subject matter jurisdiction is when a civil claim implicates a federal civil law, like federal anti-discrimination law or something of that nature. Whistleblower protection law, that's a federal law. That would end up in federal court because it's a federal law, so subject matter jurisdiction. Diversity jurisdiction means that you have a claim between two parties who are residents of different states, and you have a matter involving $75,000 or more. The reason why diversity jurisdiction exists is because people were afraid that the state courts of one state would favor the resident of that state over the non-resident. And so there is a way in more high-level cases, so there is a dollar amount threshold, where you can have your case heard in federal court. On the criminal side, the only criminal actions that you will see in federal court are federal crimes. So counterfeiting money, mail fraud, tax evasion, terrorism, those are all federal crimes where you'll see those trials take place. You'll also have the appeals for the federal crimes as well. But habeas corpus appeals can happen in federal court, which may be based off of state criminal matters. Habeas corpus cases are cases in which people are challenging the way in which they're being held, usually in prison, but sometimes can involve potential death penalty as well. So they're another way to challenge a criminal conviction, but on different terms, usually having to do with how the person is being held unfairly. Habeas corpus meaning let the body go. So once you have your state appeals run out, you do have a line of federal appeals, but it's a limited review for habeas corpus. State cases, on the other hand, have kind of a broad set of categories. State cases are more numerous, and if you are involved in a court action, it is more likely than not going to be involved in the states. On the civil side, any tort, so a wrongful action case, someone owed you a duty and failed to provide that duty. So slip and fall cases, auto negligence cases, any kind of negligence or reckless behavior cases, those are torts. Contract cases, or any other common law claim usually will end up in state court. State statutory claims, so states have different statutes that may protect more than the federal statutes. For example, Michigan's anti-discrimination laws include weight, height, and familial status, meaning whether you have children or not. And so if you're suing on those bases, you'll have to sue in state court, not federal court usually. And then family matter claims, which includes divorce, adoption, marriage, which we don't typically think of being a court action, but it is. All of those things are state matters. And then on the criminal side, most criminal cases are state cases. Even murder cases, capital murder cases, are more often than not state cases. Federal crimes are pretty limited. They require you to be breaching the Constitution or a pretty high-level federal law. Otherwise, they go to state courts because it's based on state law. So that brings us then, after we go through the district and circuit courts, to the Supreme Court. There are 9 justices on the Supreme Court. There's 1 Chief Justice and 8 Associate Justices. They are appointed for life, meaning they are there until they die or until retirement. The Chief Justice leads the court. There must be a vacancy in the Chief Justice role for there to be a new Chief Justice. So once someone has that position, they don't leave it. They're there for life until they resign or die. It doesn't rotate around or something like that. And when that happens, the president can say, hey, Justice Smith, you've been on the court a while. Why don't you become Chief Justice and I'll nominate a new Associate Justice? Or, like what happened with Chief Justice Roberts, the president can appoint someone entirely new to be Chief Justice. Our justices are notoriously both kind of famous but not famous. And I say that because they are the most visible judges we have in the court system. At the same time, much of what they do happens behind closed doors. So if any of you watch John Oliver, you'll know the picture from on the right is what is the canine Supreme Court, because John Oliver did a segment about how the Supreme Court does not allow cameras inside during oral argument or when opinions are given. And so they allow audio. So he challenged people to pair the audio with these dogs, and many people have. You can look up some Supreme Court cases with the audio. There have only been 2 times when a camera has made it into the Supreme Court, and it's a crime to do that. So I would not suggest it. But that means that these justices wield a lot of power, and quite often our perception of them is limited to what we hear in sound bites on the news. So first I want to go through how the cases work at the Supreme Court, and then maybe some more information about the justices themselves. So there are 2 main paths from the lower courts to get to the Supreme Court. The most common path is that there's a case that is in federal district court. It gets appealed up to federal circuit court, and then goes up to the Supreme Court. That's a pretty straightforward path. It's right up the left side of that chain of command we talked about earlier. The other possibility is a review of a state court decision, and the Supreme Court can review cases of state Supreme Courts if the decision interprets or infringes on a U.S. constitutional component. So if there's a search and seizure component to it, it can be heard at the federal Supreme Court. But the most common path is district court, circuit court, Supreme Court in the federal system. There are several steps in a Supreme Court case. What is important to know here is that the court does not have to take the case, which we'll talk about in a minute. If they do take your case, though, there will be written briefs, then there will be oral arguments, and then there will be opinions that are issued. The written briefs are each party files briefs with documentary evidence and supporting cases that argue their case. Then they will have oral arguments before the judges where the judges can ask questions and the attorneys have to answer them. And then opinions are issued. There are various types of opinions. There's a majority opinion, which is the opinion that the most justices agree with, and the one that provides what's called the holding in the case, or what the case stands for. In other words, the main decision. There's the dissenting opinion, which means it did not win but wants to have its voice heard. A concurring opinion means it agrees in the outcome but disagrees with the reasoning. And a per curiam opinion means no one wanted to put their name on it, and so it's just a statement of the decision. So the Supreme Court's jurisdiction is split in 2, and for a minute I want to focus on appellate jurisdiction since we were already there. The court's primary role in our society today and in our governmental system is that of appellate, Supreme Appellate Court. And so it hears cases from below, but there is no automatic right to appeal. So if you lose at district court, you can automatically appeal at circuit court. However, if you want to appeal the decision further to the Supreme Court, you have to ask them for permission to appeal. It's a process called applying for a writ of certiorari, or writ of cert. and less than 1% of all petitions for writ of cert are granted. So they get thousands of petitions each year, and most of them are denied. What you need to show typically to have the Supreme Court take your case is that there's an important national controversy about a legal interpretation where there are differences in how courts are treating it. So usually that means something like two circuits are interpreting the same thing in different ways. That's called a circuit split. And sometimes the Supreme Court believes something is just of national importance, that they need to be the final word on it. But you must show that the Supreme Court has to step in to settle this important national controversy. Most cases are denied cert. There may be other factors in whether the Supreme Court takes your case or not. Justices that may actually feel favorably to your side may not take a case because they know they don't have enough votes, and so they don't want to set bad precedent. And they might just want to let the decision below stand, that that's the best that can happen right now. So there are a variety of reasons. Typically, though, the reasoning is that whatever has happened below should be settled law. There is original jurisdiction at the court. Original jurisdiction means that there are original cases that the court hears for the first time and that no one else hears before them. So it doesn't go to the district court or the circuit court or a state court. It goes directly to the Supreme Court. These are the only types of cases discussed in the Constitution. In Article 3, Section 2, the Constitution outlines the court's original jurisdiction and gives 4 types of cases that the court can hear. The first is disputes between 2 or more states. And in fact, not only is this a case where the states can go to the Supreme Court directly, but that's the only place they can go. There's no other court that can hear those disputes. And you can understand why. District courts are located within a state, and for the same reason we have diversity jurisdiction, we don't want one court favoring one state. So those go directly to the Supreme Court. The rest usually involve some measure of kind of interstate or international relevance. So actions involving ambassadors, public ministers, etc. of foreign states. Controversies between the United States and a state can either be original jurisdiction or appellate jurisdiction. And all actions or proceedings by a state against the citizens of another state or against aliens can be original jurisdiction. The last 3 you can start at district court and work your way up, but you don't have to. You can go directly to the Supreme Court. However, the court retains the right to hear those cases, but they don't have to. The only one that they have to is the disputes between states. So that brings us to who these unelected, appointed for life people are. The demographics of the Supreme Court are pretty homogeneous. Race and ethnicity are not very diverse. Only 2 blacks have ever served on the court. One is currently on the court, Justice Thomas. The other one is who Justice Thomas replaced, Thurgood Marshall. Only 4 women have ever served on the court. 3 are on there currently. And the first one only was appointed in 1980. That was Sandra Day O'Connor. And the second one was not appointed until 1992 or 3. 3 it would have been, when Ruth Bader Ginsburg was appointed to the court. Obama appointed 2 women, Justice Sotomayor and Justice Elena Kagan. Ethnicity, only at least one self-identifying Latino, or actually Latina, Justice Sotomayor, although some consider former Justice Cardozo Hispanic. So the ethnicity is pretty white. Pretty Protestant. Usually the Supreme Court has been fairly Protestant. However, now the composition is actually Roman Catholic and Jewish. And all current justices are over the age of 50. Kagan was the youngest at the time she was appointed and was 53. She's now, I believe, in her late 50s or early 60s. Justice Ginsburg is currently the oldest. Most of these justices go to Ivy League schools, at least for law school, if not both for law school and undergraduate education. And most of them have careers that are pretty elite. They are law clerks themselves for the Supreme Court, or a variety of other high-level positions. In other words, no matter how you break it down, the Supreme Court is actually a very undiverse part of our government. Now, that's giving the rest of our government a lot of credit. Most of our governmental positions have minimal diversity at best, but the Supreme Court is still pretty white, pretty male, pretty Judeo-Christian, and certainly fairly elitist in education and background. Why does this matter? Well, people believe, and we'll talk about this next week, that the judges do not isolate their own identities from their judicial decision-making, and so people feel that a judicial body that looks more like America is important. Now, one of the ways in which it's pretty isolated is that the cases that come to the court often feature repeat players. So what is called the Supreme Court bar. People who actually argue cases at the Supreme Court, more often than not, are returning people. Either they have been Supreme Court clerks, which is like the best job you can get out of law school ever, or they are former oral advocates who have clerked for a sitting justice or have argued before the court in the past. So what you see here is a chart. There was a Reuters report about how rare it is to have new people arguing before the Supreme Court. What you'll see is that if you are a former Supreme Court clerk, you are more likely to actually argue before the court in future cases once you leave your clerkship. And so it's kind of a small community. At the same time, law clerks can go on to become Supreme Court justices themselves. There have been several law clerks that have gone on to become Supreme Court justices, including Byron White, John Paul Stevens, Rehnquist, Breyer, Roberts, and Kagan. And in fact, right now, Neil Gorsuch is nominated for the position on the Supreme Court, will likely get that position, and he himself is a previous Supreme Court justice. I believe he clerked for two justices, might be Byron White and Kennedy, but I know Kennedy for sure. Another key player is the Solicitor General. The Solicitor General is the U.S. government's representative at the Supreme Court. This is the top appellate attorney for the United States. The Attorney General is the top prosecuting attorney. The Solicitor General works under the Attorney General and is the top appellate advocate and argues frequently before the Supreme Court. In fact, if the Supreme Court believes that the United States government should have a voice at the court on an issue, even if they're not a direct party, they might invite the Solicitor General to argue. Former Solicitor Generals have become Supreme Court justices, and you'll see the list there, including current Supreme Court Justice Elena Kagan, who was both a law clerk and Solicitor General and now a Supreme Court Justice. So this is a small, close-knit community, very few outsiders, and a lot of repeat players. Now, to finish up our discussion of kind of boundaries and duties, I want to talk about the case of Marbury versus Madison. If you have not watched the video I posted yet about the background facts of the case, pause this video and go watch that, and then come back. If you have watched it, welcome back, and let's talk about Marbury. The issue in Marbury, the factual issue, is whether or not Marbury could take his post as a Justice of the Peace for Washington, D.C. Seems like a simple, straightforward administrative mix-up case, and it could have been deemed that. However, the stakes were pretty high here. We had a changing of the guard from Federalist-held government to Democratic Republican-held government with the Jeffersonians coming in. And Chief Justice Marshall, who was involved with the facts of the case, as you'll note from the video, is the one who is writing the decision. And the legal issue gets involved with this case is whether or not the Supreme Court could invalidate a law of Congress or an act of another branch of government. In this case, there was a provision of the Judiciary Act of 1789 that said that there was a legal procedure called a writ of mandamus. And the writ of mandamus was a provision that allowed someone to file a case directly at the Supreme Court in limited circumstances. And so Marbury took his case directly to the Supreme Court. As you notice, I didn't mention it in the previous slides because in this case they invalidated it. The court said not only does Marbury have to go back, but that part of the Judiciary Act was unconstitutional because it had no basis in the constitutional language that set up the jurisdiction of the courts. On a larger scale, the issue is not whether the writ of mandamus is possible, but what the case stands for today is what the role of the court is in our society. And the two words you need to remember here are judicial review. The idea of judicial review, the idea that government actions, whether the executive branch or congressional acts, can be reviewed by the judicial branch, in particular the Supreme Court, stems from Marbury versus Madison. The court ruled that it had the power to review acts of Congress, that all legislation passed by Congress was subject to the power of judicial review, and that the Supreme Court was the ultimate arbiter of what was constitutional. In this case, the Judiciary Act of 1789, that portion that dealt with the writ of mandamus, was ruled unconstitutional. In doing this, Justice Marshall said, "It is emphatically the province and duty of the judicial department to say what the law is." This means that judicial review is not found in our Constitution directly, although it's implicated in the Federalist Papers, but judicial review is implicated in Marbury versus Madison. That prior to this, judicial review wasn't written down in Article 3 of the Constitution. It comes up in Marbury versus Madison. And so the power of our federal court system stems from this case more than almost anything else that we will talk about. So understanding that, it's important to read Marbury versus Madison and have a good grasp of what the case means and its implications for the future, including why the federal government might be involved in something like same-sex marriage. Marriage, as I mentioned, is something typically left to the states. But does that mean the Supreme Court can't act at all? Well, as we've seen in the past decade, that is not the case. The Supreme Court has a lot of room to act, and your reading points that out. So, with that, I'll leave it there, and we'll come back to do more on the judiciary and judicial behavior next week.